thinking about it. Okay, now we're live. We're good to go.
Right.
Worldwide.
So I'm sharing my screen. I want to make sure everyone can see me or see my screen. Shouldn't be me, actually. Where? There we go. View. Presentation. Awesome. So welcome everyone to General Assembly Boston. We're virtual Boston tonight, so that's just fine. Thank you so much for being with us. My name is Nicole Carrasquillo, and I am a frontliner at the GA Boston office, and I'm here to share with you a little bit about GA before we kick off the event tonight. So General Assembly is a global education company. We specialize in teaching things like coding, data, business design, and more, such as events like this. We are a global leader in education on 30 campuses worldwide, and we've been around since 2011. Cool. We have, I feel like I skipped one. There we go, yeah. We offer courses in a couple of different ways, both online, on campus, full-time and part-time. And so we service individuals in very different walks of life. Whether you're someone who's looking to shift careers entirely, you can jump into one of our immersives. If you're someone who's looking to just up your skill set, you can maybe do one of our part-times a couple nights a week. Or if you're just getting started and you're curious or wanting to dabble, we have one-day courses, boot camps, and then online events just like these. So our 3 immersive programs, those are the full day 9 to 5. Those are typically for individuals who are career changing, interested in software engineering, data science, or user experience design. And then for the part-time programs, those are in the evening, typically like 6:30 to 8:30, 2 nights a week. Anything ranging from Python, React to user experience as well. So here at Boston GA, we're a lovely community of tight-knit folks, and we invite everyone to keep in touch. You can email us at boston@ga.co if there's any way we can help you, and that includes connecting you to our network of speakers who you hear from tonight, or any other individuals that we might have in our network. As well, jump on with us on social media, both Instagram and Facebook listed here. Tonight, we have for you the future of law, legal, and tech. I am going to introduce our speakers by first name only tonight. They are Igor and Sangeeta. Igor is president of FastCTO, and Sangeeta, principal shareholder and managing attorney, Law PC. They will tell you more about who they are, what they do. But before we get started, why am I stuck? Oh,
it's probably this picture of me. This picture of me broke your screen.
It's the last slide anyway, so I'll share my face again. I just wanted to let everyone know that this webinar is going to be recorded tonight, and it's also being featured on our live stream. So any attendees on our webinar tonight, your microphones are muted, your videos are muted as well. So we can't see you, although you can see us as well. We can't hear you, so please definitely use the chat box to throw any of the questions that you might have. And then to receive a recording of this webinar, make sure you sign up at the link that I will provide in the chat box. And without further ado.
Or follow FastCTO on YouTube or Facebook or LinkedIn, and they'll be in there as well.
There you go. Stay in touch.
I don't want to swipe it from General Assembly, but you should connect all of us. Yeah, for sure.
Absolutely, absolutely. Thank you, Igor.
Okay, so I guess I'm going to share the screen.
Yeah, share your screen. I will mute my video, but I'm here with you.
Okay.
Beautiful.
Igor, you want to take it off? Go ahead.
Oh, boy. Okay. So, hi, everyone. My name's Igor Belgorutsky. I've done a lot of stuff, but currently I am the president of FastCTO. And what we do is a lot of things, but basically help startups avoid mistakes. Mostly technical, but sometimes operational, legal, and elsewhere. Our mission is we don't profit from startups. Instead, we profit from VCs and private equity and the folks that can afford it. Yeah, you can read a lot more about me all over the place.
I love it. My name's Sangeeta Savaraja, and I let Igor go first because I can't say his name, but we're doing Future of Legal and Tech right now. I am a corporate attorney, and I run my law firm, Salvador Law PC, and also FastCTO, which is an educational resource for CEOs to profit. So we're running something called Future of Legal and Tech, and I'll get started. We're giving you a short summary, but we can get into greater detail here. And if Igor, you want to summarize this up, or
sure, yeah, I could do that. So basically, I've started a lot of startups from high school, after high school, college, after college. Most of them failed. A couple of them didn't. Some of them failed for legal reasons, in fact, which maybe we could touch on today. Some of them failed for non-legal reasons, but with a lot of legal repercussions, which we could maybe get into today. And some of them just failed because they were terrible. So failing is maybe not the right word. Yeah, in the last couple of years, they've all been good. So I'm learning.
Learning's always good as well, too. So that's Igor. This is me. I'm a startup attorney past 10 years at my law firm. Been a small business advisor for past 15 years, and I've also advised and legally counseled over 150 companies. I teach other entrepreneurs and lawyers on effective risk management, starts, business topics, and how to grow your best team as well. Like you, also an entrepreneur, like Igor, also an entrepreneur. I started 4 different companies, merged one, failed at one. So I'd like to think I failed successfully at that too, you know. And now I'm currently running 2 corporate law firms as well as FastCTO. Well, and now let's actually get into what we are going to touch on today. So we're going to talk about the top issues in tech. Actually, Igor is going to touch on that. And then I'm also going to talk about the top issues in legal. These two definitely overlap. So we might cross-pollinate here and talk about our all our situations that have arose over the last few years. And then we're going to bring it back to what's the best practices that we think would work for a company and you as an entrepreneur through this journey. Okay. So I'm going to let Igor take it out for the first 10 minutes.
Sankita, do you want to do a little legal disclaimer about your answers before we get into it?
That's great. Thank you, Igor. So it's an educational seminar, and it's purely for educational, informational purposes. This does not create an attorney-client relationship between you, Igor, myself, Nicole, or anyone else on this panel, or your fellow attendees. Okay, if you would need some legal advice, please contact your specific legal practitioner. If you
Very
agree,
nice.
by utilizing this program or coming on, you, by implicit consent, you agree to this.
All righty.
Igor, do you?
I don't have such a disclaimer. Everything I say is always factual and correct, except for maybe a tiny list of 3 or 4 things that my wife actually keeps on her phone to remind me that I am wrong occasionally. So there we go.
Oh my God.
I really want to disclaim the fact that I don't let Igor speak for me as well. And Igor is not going to really open calls.
All right. All right. So these, when we go through the tech mistakes and tech problems that we're going to talk about, I didn't put these in any specific order, actually at all. So some of them may apply to you, some of them may not. Ask questions and we'll figure it out. So the first thing, and then the other thing is there are a lot of tech issues, right? There's a lot of when you have a startup and there's technology involved, a lot of choices you have to make. Some of them have more of a legal bearing, and some of them less. I deal day to day with a variety of technical decisions. For today's lesson, whatever we want to call this event, I've kind of handpicked ones that have a legal overlap. So these are not necessarily the most pressing technical issues that a technical software company or technical company might have, but from a legal perspective, they are. Okay, so the first one is certifications, right? If you are collecting personal information, if you're processing credit card information, Social Security, health stuff, HIPAA, if you're selling your software to any entity that that is a government body or a healthcare body. They might require certain certifications, ISOs, HIPAA, which is a weird one, SOC, SOC 1, SOC 2, Type 1, Type 2, whatever. All of these are useful to an extent. And what I basically want to talk about is when you should get them and if you need them, right? Because some of them, and Sankita, interrupt me if you disagree, or anybody else, throw your question in if you have a use case or an anecdote where I may be wrong in. But basically, some of these are a must-have for certain situations, and some of these are not, basically, right? So as an example, SOC, right? So SOC certifications are basically somebody making sure that your processes are sturdy, redundant, you know them, et cetera, right? I've seen a lot of small startups think that they need a SOC certification. They think because they're going after some client and they're like, oh, well, there's no way we could sell to that client if we don't have it. That is almost always not the case. At some point, you do need it. But from my experience working with fintech companies, healthcare companies, government entities, basically, you don't need, as an entrepreneur, you don't need a SOC until someone asks you for it. And when they ask you for it, 99% of the time, it's enough to basically say, okay, are you all right with us taking steps toward it? Can we start engaging? And almost always the answer is maybe yes. Sankita,
ask you this now. Yeah, so with SOC and with definitely HIPAA, you have to comply with HIPAA rules that if you're taking any sort of health information, whether it's online or in person, you have to follow HIPAA rules for protecting that patient's confidentiality and patient records, right? SOC and any sort of governmental side, if they are requesting you to prominently display your certification, then you should. Absolutely what Igor was saying. Now, if you are connecting with another external third party, you should also put your certification number as well, just if not for any sort of credibility, but legitimacy as well. Okay, so it's not just about a requirement, but just also increase legitimacy as to the Fed. It increases the other party's comfort or assures them that you are also complying with certification requirements as well. Okay, so it's there's a soft here and there's a hard value here where you should comply with. Go. Sorry to interrupt.
No, it's fine. Sankita, a question I actually very often have about HIPAA when I work with companies is what it means to be HIPAA compliant, because unlike some of these other ones, it's not actually a certification, right? So for ISO, you get certified. There's an auditor that comes in and certifies that you comply. For SOC, there's an auditor. For HIPAA, you just have to make best effort. Can you talk about what that really means?
So when you take in any sort of patient intake, so if you're a healthcare company that operates online, or if you're a healthcare, such as a doctor, acupuncturist, even PT, any of those sciences as well as software sciences, where you are taking in somebody's personal healthcare information, you have to be a company. What that means is you follow the HIPAA rules of protecting the patient's privacy as best as you can, and follow them as it's a confidentiality practice more than anything.
Exactly.
Okay? Yeah, that's what it is. You don't get certified.
Yeah.
And you know what expects you to be certified, but it is a best practice rule.
Yeah. It's very similar, if there's any technical folks in this call, it's similar to AllWASP, right? So AllWASP is a guideline of how to write secure code rather than a certification. And a lot of people will ask you, or clients might ask you, are your developers AllWASP aware? And as long as they know best practices and are following them, then you could say confidently yes. It's very similar with HIPAA. I will say, PCI. So anytime you're storing like passwords, social security, credit card information. Well, don't store. You almost never have to. Specifically with any sort of payment information. That's why there's Stripe. Use Stripe. Use what's the other one? Starts with a B.
Authorized.net. There's Authorized.net. Any third-party processor is your best bet.
Exactly.
For those type of things, because either way, you still have to be PCI compliant as well. Like for law firms, sometimes we use something law. They require us to be compliant and do a test every year, actually, because we would take this type of sensitive information. So it depends on your process, but ideally you want a third-party processor. So Igor mentioned Stripe, very popular.
Yeah.
Authorized.net, PayPal. Okay.
Yeah, there's a bunch.
Yeah.
And same thing for authorization, right? Don't try to don't store passwords. Obviously, if you have to hash them, but if you're storing hashed passwords, basically you're probably doing something wrong. You should still use a third party like Firebase, like Okta, Auth0, Cognito, whatever. Offload that to companies whose core expertise is the security of that data. Because chances are whatever you're building, that's not your core expertise. Focus on your company, let other people focus on the security. And on this one slide, before we go on, just quick side note, if you are pursuing SOC, type 1, type 2, whatever, ping me afterwards, and I can at least point you in the right direction of what not to do and what to do. Because that's one I have.
Any questions so far?
Oh, I don't see any questions in the chat, and I don't see any questions from the world. And I think we can go on.
Okay, so this is something that overlaps both of us. The tech mistake here is GDPR, ARIA, etc. trolls. I'll let Igor touch on this, and then I'll follow up with what it means on the legal side.
Yeah, so I actually, I have a maybe primitive view of this. So Sankita, you can yell at me after I say how I feel about this. So I think that most people are concerned for not a legitimate reason. Not that there isn't a legitimate thing here. If you are selling to anywhere in the EU, you have to comply with GDPR. If does anybody know what ARIA is? So it's basically, I forget what it stands for, but it's making sure that your application is accessible to hard of hearing, eyesight impaired people, and there are actual government bodies that levy fees to companies that don't comply with this. And over the last couple of years, there have actually been a number of, we'll call them trolls, that basically prowl the internet, find companies that don't comply with some either important or non-important thing, and basically file against them and win money. I mean, it's not hard to comply. I guess my point is, whether you think that there's something here or not, it's not hard to comply with these things. As long as you're doing it from the get-go. It's much harder to do after the fact. So do it, and don't lose money to trolls.
So I'm going to agree with Igor here that it's not hard to comply. It's actually pretty easy to comply. One of the issues that we come up is thinking that they don't matter. The fact is, the GDPR, while it is based out of the EU and it applies to EU residents, it also really applies to anyone that would be taking in EU residents' information. So the GDPR went into law May 25th, 2018. Soon after, California passed its own Consumer Privacy Act on June 28th, 2018. So this is now the American version of that. And California has very similar laws as the EU, but also needs to comply for data privacy. What does this mean in English? This is under your private policy. So any website that you have, web page includes your blog, your website, your consent form, your intake form, your newsletter, anything that is labeled as a web page that you take in any sort of information that could be labeled personal. So name is personal, email is personal, any sort of statistic, demographical information is statistical, and that needs to be complied with. And this can all be listed in your privacy policy. So make sure your webpage, whatever it is, has a terms of use, separate document, or privacy policy. Sometimes you see them together. Most of the time you see them apart. You see them as terms of use or terms of service or website privacy policy. The GDPR and any compliance with the CCPA, California Consumer Protection Act, would fall under or within the Privacy Policy Act. So make sure your own privacy policies are compliant. If they're not, or you don't think they are, take them to an attorney and have them review this with you. But definitively, this is one of the most important documents in data privacy. And so this does matter. And so what we come up against is where people don't think that it matters, or it's fine to just cut and paste somebody else's privacy policy. You don't know if that privacy policy is compliant. So make sure that it is compliant with your industry, with your sector, and with your particular company as well.
So Sankita, since you kind of brought it up, a question that I often get asked is, I'm a bootstrap startup. Can I go to like a Rocket Lawyer or one of those and just click and get a terms of service and privacy policy? Like how confident should I be in the document output from there? Like, can it hold me over at least for some time?
So, Rocket Lawyer,
or similar,
they all have their place. And ideally, I don't think they're bad companies. Actually, something is better than nothing. You just have to make sure. And most of those documents that you see online right now, they are GDPR compliant, right? It's 2020. Those laws went into effect in 2018. We've had like almost 2 years to come up to this, not here. So if you are using those services for that, make sure that they touch upon the GDPR and the CCPA as well. Do your own due diligence and read through it. And then obviously, if you're not comfortable with that, go to a lawyer and have them do it for you, or to edit the document that you already have.
Yeah.
Okay.
Thank you.
The other tech mistake, and Igor and I, we're going to have lots to talk about this. Okay?
Yeah. So I'll give you guys an actual thing that happened. This happened, I think, in October. So about 6 months ago, we had a client come to us, and basically this is a very common thing where they've spent some amount of money at a dev shop. I think this one was in for about $30,000, and basically got nothing for it, right? Nothing worked. It was half done, all this kind of stuff. And they came to us and they said, look, we don't know what to do. And they're refusing to fix it. And they're saying it's going to cost this and this and this. And I said, well, is this a time and materials thing where you're paying them by the hour? Or was this an SOW where you signed something ahead of time? And she said, oh, it's an SOW. I'm like, okay, let me see the SOW, right? And so an SOW is like the worst thing you could sign. It'd be on the receiving end of a dev shop's SOW as an entrepreneur, right? So we're talking about a pretty sophisticated platform with an app, reports, maps, like user information, authorization, like all this kind of stuff, payment processing, memberships, right? And this SOW was like 4 pages, right? So regardless of how straightforward it might be, like no dev shop could execute on 4 pages worth of information and give you what is actually in your head, right? And so the founder was telling me like, well, they promised us reports and there's no reports. And so I look on page 3 of the SOW where it lists all the deliverables, and literally there's a bullet point that says reports. I'm like, okay, is there more to it? It just says reports. Yeah, so like the SOW literally just said reports. And there was one page in there that basically said like how many users are signed up. Theoretically, that could be counted as a report. And the dev shop was saying, according to the SOW, we did it, right? So basically, it's terrible. She, like many other companies that we work with, basically she lost the money, right? And it's a $30,000 mistake for her. Some folks come to us, they learn their mistakes in $10,000 or $15,000. However, we have clients that learn their mistakes in $80,000 or $120,000, right? So on this one, I could shortcut this all together and say, don't engage freelancers or a dev shop, period, as an entrepreneur. And I'll come back around how you could do it, right? And I don't want this to be a sales pitch for FastCTO, but obviously through FastCTO. But it's true, right? Because that's what we do. We don't make money off of you. But anyway, yeah. So that actually had legal implications, right? And this, she had no recourse, right? And Sakita, you could speak to this, right? It's a signed SOW. It's her word against theirs, and technically there was a report, and the bullet point said reports, for example.
Can I chime in?
Yeah. No, that's why I paused.
So I see this all the time, and it's terrible how much that people think that if they have a contract, they think that it's enough. It's really the words in the contract that matter, okay? Reading is still fundamental and still necessary in all parts of every part of your engagement with a freelancer or a dev shop. I'm not going to agree with Igor here. I'm going to tell you definitely if you should want to engage with a freelancer or a dev shop, you can. You just have to be conscientious and good about it as well. And one of those things is making sure you have an SOW, statement of work, or sometimes there's a work for hire agreement, freelancer agreement, independent contractor agreement. There's many different ways on the street what you can call this. What it really means is it's a summary of your understanding, both of your understanding of what work needs to be done and how much payment should be done. How you can prevent this situation that Igor went through or Igor's client went through, is that before, if she had signed an SOW that did something where she made milestone payments, that would be another aspect of it, where the freelancer or the dev shop wouldn't get paid unless they met that milestone, okay? And then they don't move forward until they meet the milestone, and then they get paid. That's one way you could actually label that out and put that into the SOW to state that. Another aspect is to be really clear. Like, just because someone's a contract doesn't mean it's the word of God here or whatever spiritual entity you pray to. It is literally an opening or negotiation. So you can read that contract and you can say, you know what does this mean? And when is this due? And what are your expectations if this scenario happens? This is what's called conscientious negotiating, right? So reading through it, understanding it, and seeing how it plays out in your world. What does that mean? Because sometimes when people give out contracts, people boilerplate, where this is what they give to everybody, right? Now, your situation could be different, and you're not like everybody else. So you reach that contract is typically catered to you and your expectations. Another aspect is making sure that you have the recourse to terminate the contract if they do not perform. Okay, so if they don't do X, Y, and your expectation is X, Y, you have that out to terminate the contract without further payments. So that should also be in the contract as well too. What is the cause for termination? And also making sure that it's something called creative control. Sometimes you can see this in contracts where you will see that specifications on a specific job can't fall until you say it's up to your standards. Okay. Now the dev shop or the freelancer might push back because that is subjective. But if you are looking for a very specific product, you should have some kind of say so about how it's going and whether things need to be tweaked, right? this also requires you to be conscientious in the actual application of the contract or the specifications of the freelancer. So if they started work, you also have to check in and see how is this working. Are they following up every week? Is there a status update? So you can actually put that into your contract and say, in your deliverables, this is due at this point. What needs to be done? You need to sign off on it, et cetera, et cetera. Okay. These are ways that you can prevent that situation from arising. Now, what if you are the dev shop or freelancer? Okay. So one thing you can do to protect yourself is have a contract yourself. Okay. A contract that, when we say this in any law and stuff, is the best defense is to be in the offense. Having your own contract is an offensive or a very defensive situation where you come out and get to dictate your terms ahead of time. Now, this helps you because then you know your business better than you. You also know the flow of it. You can also protect the terms and how things can play out. It's up to your client to push back or to clarify. If you are the freelancer and you have a contract, do something. Ask for a deposit up front, right? Because your labor is still considered labor. You should be charged for that. Ask for a non-refundable deposit of maybe 10% for you to start work. So if you give your contract and your client is reviewing it, take a deposit and say, we won't start work until 10% of quota price down. Because that shows that the client is ready to play, so to speak. And you at least have that 10% to work on so you meet that deliverable milestone as well too. So that's one way of protecting yourself as the freelancer. So you can see how a contract can work for you in either position, either as a dev shop or as your own freelancer or whatnot. Okay, yeah. So again, read defensively. That's what I can tell you the best way.
Yeah, I have a lot more thoughts on this that I'll hold. But I will say, Sankita, you touched on this briefly, but anytime a contract goes from one party to another, you should assume that the party giving a legal document, the document favors that party, right? So anytime you receive a document from someone, assume it favors the person that gave it to you, right? So read through it. Huh?
No, I'm agreeing with you.
Yeah.
You absolutely should believe that it favors them, and it's your job to actually read through it and negate or push back on certain clauses.
And that's true, like in life. It's not just for the purposes of your startup or your thing. Like any contract you'll ever get will favor the person giving it to you. And so that's why you work with a lawyer, by the way, not to plug Sankita, but you work with a lawyer so you get contracts that favor you. So when you hand them out, they're already slightly tilted in your direction. Not unfairly, but like the terms maybe like something's a little shorter so it suits you, something's a little longer so it suits you, right? And it's their responsibility to push back on it. That's kind of the game.
And it's also great for you to, if you do have a contract set up, and you have to know what those contract terms are. Like just because if you go to a lawyer or you get one off of Rocket Lawyer or wherever, you have to understand what each of those terms are, because when you present it to a client, they're going to ask you what this means. So if you don't know what your own terms of your own contract are, that's not a good day for you. So you might want to reach out to an attorney or somebody else, definitely an attorney, to have them review it and also to bump it up, update it as well. And just to see how, and have them explain to you what these terms are. Sometimes if you have a pre-existing contract, sometimes you just have to go to a lawyer and they can just explain it and also augment it. And consider your contract as a living document. Take a look at it every year and see what happened. Like, did some situations come up that you want to protect for in the future? Like, oh, I had this terrible client that, pushed back on the clause and I wish I had something that protected me here. So you can every year try to sex up your contracts a little bit even more, okay? What worked and what didn't and so forth. Because all of these contracts are living documents. Don't just get it one and done. It doesn't work like that. Because what if you have a contract and you don't have a GDPR or a CPT in there too? But moving along, as you can tell, we have thoughts on this is also and a state. I'll say this: pursuing a co-founder, technical or otherwise, without a clear understanding of roles. Can I take this, Igor? And then
please, yeah.
I have thoughts. So let me say this. Co-founder is a partner in your business. Think of it like that. And in terms of liability and risk, your partner's mistakes become your mistakes. Okay? And so you also should know who your co-founder is, what their limitations are, what their skill sets are, and also be able to expect and work around them. Okay? So when we counsel clients, actually, if somebody comes in, a set of partners come in and they want to start a company, right? We don't even form the company until they do a 30-question questionnaire. Actually, it's done by David Finkel. And we send them off. Hey, do this 30-question questionnaire, okay? Come back, have a glass of wine, coffee, whatever, and sit down and go through these questions. You'd be surprised. These questions actually ask, how well does your partner handle conflict? What are your partner's skill sets? Do you trust your partner? What happens if you pass away? What happens if you are disabled? What happens if your partner is disabled? I add this question all the time when I ask partnerships. I go, are you married? And some of them are, some of them not. And then I go, are you in danger of getting married? Okay. The reason being is if you enter into a partnership with someone and say they pass away and they're married, their spouse now technically gets put in the shoes of your partner. Now, I don't know about you, but most people enter into partnerships with the person they initially started the partnership with. So you have to ask these questions and know these things about a co-founder. Now, the way the tech works is, I need a specific skill set. I'm going to bring on a co-founder. Now, there's a lot of questions you should ask beyond that skill set that is required.
Yeah.
Okay. So just because bringing on a co-founder means owner means equity in the company. Now, you could bring on one that's, a contractor. That person has no ownership in your company, and they are only there for the specific time and the job that is required of them. So know the difference here. And that's perfectly stated with how Igor stated how without a clear understanding of roles. So that also the onus comes on you. What do you want from this person? Or what kind of job do you need this person to do? If the job is very specifically delineated, you should quote unquote date a co-founder first. What that means is bring them on for a trial run for anywhere from 90 days to 180 days to see how you work together before you consider coming on as equity partners in a company.
Yeah.
Okay. I'll pause here.
I don't see any questions from the audience, but I'll add, you can go out there and Google all the reasons why startups fail, and you'll get like a list of 1,000 different reasons. 99% of them are really one of two things: co-founder issues, or you ran out of money because you squandered it on something you didn't need to, right? And some flavor of that, right? Out of all the startups I've personally had that failed, not one of them was because of money. It's all been either, well, some of them were because the thing that we were doing was just stupid. If it wasn't a money issue, right? But we could have thrown some money at it. It still would have been stupid. But the ones that like really failed because co-founders.
I'll co-sign on that too. One of my startups that failed was because I had two other co-founders, and it was amicable. It was great, but we just didn't all agree on the vision of that startup, okay, and where that needed to go. And it wasn't crazy. It wasn't, no one went to court. There was no fist fights. It wasn't like, a Real Housewives of startups. It was really, really just on the sense that we worked on it for 9 months, every weekend, every night, whatnot, and it just didn't work. Now, why it was amicable is there was a clean break with a clean delineation of assets. Who got to keep what, who could focus on IP later, and so forth. So that's why I think it failed successfully, but let's just call it a spade. It still failed. And what Igor said as well, too, it was because of co-founder issues.
Yeah.
So.
And just I'll do one more point on this slide, and then we'll go over. The way, Sankita, that you failed because of a disagreement of the direction of the company is actually one of the best ways you could fail, so to speak, when it's like co-founder related. The worst way, and the way it usually happens, is because co-founders aren't pulling their weight, right?
Absolutely.
And then it actually becomes a lot messier, right? Because a lot of times, they don't come clean with the fact that they're not pulling their weight, and it's a whole thing. But that's why you have legal contracts. That's why you have a cliff in your vesting. That's why, like, if you have co-founders, you should go beyond just like an email that says, okay, let's do it for 50-50. Have an actual contract, have an actual something, use Carta, like you should be managing your cap table from day one. I'm not a lawyer, so I could say that, right? Like, you just need to, right? So when something goes wrong, there's a very clear process of, okay, like, you're below the cliff, so you're actually out, or you have 10% vested or whatever, 20% vested. So like, we're gonna buy back everything we can. Here you go. See you later. Yeah.
I'll also say this: if you're doing anything with partners, you really should engage an attorney, right? Just because of the fact that you want to have that commemorated in a solid fashion and from the beginning as well too. So if you just have a handshake deal, and one of you has 90%, the other person has 10%, and if something happens and you have to split the company apart, and you actually have to go to court without a partnership or something in writing, in Massachusetts, it automatically gives you both 50-50, right? So the person that has 90 is screwed, right? So always have it in writing, just because
that's really good to know. I didn't know that, Sankita.
Yeah, just by default, it's considered a general partnership, and if you don't have a partnership agreement, you go to court, there is really not. If you're thinking an email will suffice, it shows the intent, but until you have some sort of consent from the other party agreeing with that, email is frail, right? So you want to think about contracts as written handshakes. Think of it like that. You all agree with it and follow it up. The minute you enter into business, you should be commemorating everything. Like, there should be no more full agreements. Like, welcome to the big leagues, right? So this is where, if you have a conversation on the phone, follow it up with an email and say, hey, you don't have to be this specific. Per our station at 2:33 p.m., we did talk about A, B, and C. My understanding is X, Y, Z. Let me know if you don't agree or there's something you want to add.
I like how you rhymed that.
It's a whole rap. And so it's always great to think about it like that, just so it A, establishes the portrayal, B, it also establishes your intent. It shows that what you're thinking and your understanding of the situation is. Now, obviously, the other party receiving the email, up to them to push back if that's not what they thought that conversation really entailed as well too. And I'll have more about how to pick the partner and how to give equity away in later slides. But any more to add, Igor, before we move on?
No. Just this is super important.
Okay, here's another aspect, and we touched upon this before. So there's something in the chat. Anybody, any questions? Can you check any questions? It's a really quiet attendee.
Recording act as an agreement. Sure.
Yeah, did you see it, Igor?
So the question is, do Zoom meeting recordings act as an agreement, or should we write up and send notes afterward? What do you mean by an agreement? Shelly asked this.
A Zoom meeting, a recorded conversation agreement of that. Yeah, so if I'm understanding it, so if we're doing it on Zoom, and I say, Igor, do you agree? And you're like, yes, I agree.
And you recorded it, and there's a timestamp.
Yes, that's what she meant.
Yeah. That's thank you. That's all you. I have no idea from a legal perspective. It'd be good enough for me, like with a friend, but I could be completely wrong.
So there's two issues. Does the other party know that they're being recorded? Okay. Two, if they state that that is an accurate consent, okay. I personally like documentation that follows up that, yes, I agree with this, and so forth. Okay.
Yeah.
We're talking about if this goes to court, will this suffice as evidence commemorating agreement? That's really what that is. Okay. Yeah. Ideally, I mean, if you even put it into the chat, say, hey, we should do this. This is what I'm agreeing on, and it's timestamped. That's probably better than the actual video of it. Okay. But again, email and contract is king. So the next level up is email, because most people do that. But really, really push for that contract. Okay. I can't stress this enough. People will try to, like, you know, take it off by saying, hey, I have this on Zoom, or hey, I have this on text. Nothing beats a contract.
I agree.
Any other questions? Is that Shalin?
That's Shelly Nicole.
Shelly.
But I know no other questions from anywhere. We've got 2 people watching us online, by the way.
Oh, yeah.
2 people.
Hey, what's up?
I don't know from where, but hello.
Okay,
people,
so
wait, really quickly, people online, if you post a comment in whether you're on Facebook or on YouTube, looks like you guys are on Facebook, we'll see it as well and we can answer it or attempt to.
So going along what I was talking about, another issue I come about is not enough documentation to define and enforce. The keyword here is enforce labor roles. So we talked about freelancers, dev shops, talked about clients. And one of those things is obviously having that contract. That's what I mean about documentation to define. And also consider contracts as living documents and say, at any point, you can amend a contract. You can amend a written agreement, because if things aren't working, you can modify it. Sometimes you'll see a clause that says modification. So no modifications unless they are in a written consent. What that means is both of you have to agree in writing for the amendment to take place. Okay? So if something's not working in the contract, you can always amend it. Like, we'll see this right now, especially with COVID. You see a lot of people that can't pay certain bills, right? So you can amend their payment structure by entering into a payment plan. And what you would end up is putting in like a short, it's like 1 page amendment saying, I agree to do a payment plan over the course of 4 or 5 months, et cetera, et cetera. That is considered amendment. It's considered a modification. Both same words, they're both synonyms. Now, enforcing labor roles. So we talked about, Igor talked about how he had a client that, was, lost $30,000 because of the fact that she couldn't enforce that contract. She couldn't enforce the certain clauses within the contract to actually make her 30K valid.
Well, that wasn't even that. I would say in that case, it was because the SOW came from the dev shop, right? So it favored the dev shop. The dev shop was super shady, and they, their morals allowed the founder to, they let the founder sign this SOW, which, like, if the founder talked to any lawyer, the lawyer would be like, this is not a contract, don't even sign it, right? But she signed it, and now, she's 30K in, and like she could sue them, but that's more money out of pocket. And, usually these types of shops walk away with the money, and that's why they do it, because they're like, they don't care about the longevity of their relationship. They care about like 30K. Let's take it and you can go the other way. I mean, it's, yeah.
It's not abnormal. Like, I see it so many times when you get someone like a client that just gets leased out of it. But again, I can't stress this enough, but also the client's responsibility to be defensible as well, right? That some people just want to sign to get the job going. And yes, totally get that, because maybe you're under the gun, or maybe it's your deadline, or you want to get this deal to get on the side. That's not absolving the dev shops. Like, what did you call it? Their morals.
But to be fair, right? Like, it's, most people don't have, like, it's not their core competency to review legal documents, and so I agree with you 100% that, like, if you receive a contract, you should read it, and it's your responsibility. But I also recognize that most people can't review it with any sort of like adequate to like a adequate level, right? So it puts them in a tricky position.
So here I'll give you a three-part test of how to read a contract. So when you a contract, you want to read through it. Number one, reading still fundamental. You don't just skip over to the signature side. Okay, so read through it. Highlight the terms that you don't understand. Number one, what don't you understand? Okay. The second thing you read for is what do you understand but don't agree with. All right, what don't you agree with? And the third one is what do you agree with but want to add in there? What else do you want to add in there? So the first one is what don't you understand? Second one is what don't you agree with? And the third one is what do you want to add? All right. When you've done all of that, you go back to the person because, like Igor said, most contracts are written in favor of the person presenting it, right? So you go back to the person that is presenting the contract and say, what does this clause mean? If they can't explain it to you, red flag, okay? Then you ask them if they have a lawyer or if they have someone else that could explain it to you, you say, can you explain this to me? If they still can't do that, sign the contract. That simple. Find your own lawyer at that point before you go ahead and sign it. So at least this is your way of actually reading defensive. I understand it because the whole idea is you now put the onus back on the person that is presenting the contract to you to explain it to you how that works in what their intentions are as well. Okay, so then it becomes a joint contract because you work through it together. I cannot stress the fact that you should not sign anything you do not understand.
Except really the iTunes agreement, right?
I mean, I'm not an Apple user, so hey, okay.
That's a dig at Apple for their 100-page agreement.
I think they got that. That's
all right.
A whole different show.
What?
All right.
Wait, Nicole, can you keep us honest with regards to time here? How much time do we have?
Yeah, we're supposed to call it at 7:30, but we have had talks go over. So if we need another like 15 minutes, it's fine.
Let's try to skip through the rest and just 1 minute, 2 minutes per slide, because I think we covered the most important.
Some time for questions. So I do want to leave some time for questions. So this is all you.
Yeah. So same exact thing. It's better to so. From a technical perspective, legal aside, doing things right the first time is faster, cheaper, easier than having to redo them, right? So it's like climbing up a tree is easier to climb than climbing down the tree, and you don't want to find out that you climbed the wrong tree, right? So when it comes to security, when it comes to best practices that are outside of security, design patterns, whatever, make sure you're working with someone that knows them, make sure you're doing them. Because best case scenario, you're going to be out a lot of money because what you get isn't up to snuff and you have to redo it. Worst case scenario, what you get isn't up to snuff. You expose someone's private information and you get sued. And now you have to spend money fixing it. And also you got sued, and also you'll probably be out of business because if you're an early stage company, you can't cover the litigation or anything else. So that's why these are important. I think I just summarized it.
This is a big one. Not enforcing cybersecurity and data privacy. So this goes along with having appropriate website policies in place. We touched on this in detail earlier, but enforcing this as well is if you're taking in any sort of information by patients or kids or any user, you should also include some enforcement mechanisms within your privacy policies as well. Okay, and data privacy is huge. Given on time, we're going to move forward. So if you have any specific questions, please put them in the chat. We'll talk about that as well. Now, let's get to best practices. Me and Igor have 3 best practices here. And this is a big one. This is why I put it for number 1, is you want to consult and involve all the members of your team. All right. You might be the CEO of your own freelancer shop or your own dev shop. But if you have a CTO, whether it's FastCTO or someone else, okay, you also should be including your legal involved. And most of the time, the legal gets a bad rep. Okay, we're sometimes known as Debbie Downers. Okay, think of them more as solution Sallies. Okay, let's use that. Okay, where you want to be able to tell them the issue ahead of time so that they can come up with effective solutions for you rather than get it after the fact. Why we get as lawyers bad reps really is because most of the time we have to clean up situations. Okay, whereas if you had just told us ahead of time, we could have given you other possibilities or told you the possible risks as well, so we can move forward in a collegial fashion. Okay, so definitely include us in the conversation. Don't leave us out. We're important too. I feel like the sad child in the corner. Like, please include me as well.
I will. Let me just on this specific one, right? If you're, let's say, a solo founder, or if you have like you and a co-founder, right? The important thing here is these roles, CEO, CTO, if you're doing anything technical, but 99% of the companies are, legal and CFO, should be part of your team. And if they're not, they should be fractionally part of your team, right? So it's okay to be a solo founder and be a CEO and focus on your core competency that might be whatever, might be marketing, might be selling, might be development, in which case you're the actual like CEO / like lead engineer, technical co-founder thing, right? Then go and ping someone like Sankita to get you the on-demand legal help when you need it. Go find like a accountant / CFO that has experience in startups and in your industry and in your state, because not every CFO could do that. And some people that are actually very competent CFOs, for example, will give you wrong advice if they don't understand your industry, if they haven't worked with small companies in your state. There's a lot of little minutia and like tax implications about all stuff. And of course, CTOs, right? Like what a CTO does is different from what a technical co-founder or lead developer does. We're there to make sure you're building the right thing the right way, right? So you might go and engage developers, make sure that those developers know what they're doing. And it's not because some like project manager that's hired by some dev shop that you don't know is telling them what to do. It should be someone that's on your team, on your side, telling them what to do. And that person is a CTO. So all four of these are very important.
So I'll even say that the CFO, like even before hiring an attorney, you should be hiring an accountant or someone that in finance as well.
Yeah.
Okay, because come tax time, it's a big deal. Your money is definitely important, because you can't really have a company if you don't have money to run it or any incoming money.
I'll give you an example. I'll even plug them because I'm actually really happy with their work. So FastCTO is a Boston company. So we're in Massachusetts. We're in Boston. I'm actually using an accounting team from New York, or maybe they're even in like North Philly. I don't even know. It doesn't matter. But they have experience in Massachusetts. They have experience with startups, and they've been really, really helpful. They're the third party I engaged, and the first two couldn't answer my questions basically. So even though on paper they may have had perhaps even more experience than the team I'm working with now, the team I'm working with now, I'll actually put them in StreamYard for everyone. We've got David Fogel, who's a friend, who's a CFO. He's with Swifton. I don't know. Google Swifton CFOs. You'll find them. I always forget how to say that. But also Lanyap Financials is who I'm using, who's whatchamacallit, who's a URL I don't even know, but Swifton, David Fogel.
When you're actually interviewing attorneys and accountants, yes, you should be interviewing your attorney and your accountant as well, is to ask them if they've worked with anybody in your industry, okay? And also talk to them about your 2 to 3 year plans of what you're trying to do for your company, right? So are they picking up what you're putting down? Can they assist you in such a fashion that they can give you different types of avenues or options on how to grow your company, okay? So while you might think of legal and financial as necessary evils, really start using them as a tool, okay? Start talking to them about your opportunities or your ideas as well, and see what's the best way that you can use them and their knowledge to actually grow your company, okay? So it's a little bit of a mind shift, but I promise you it'll take you further when you start looking at them as friends rather than foes, okay? Moving on to best practice number 2, have a clear goal for all roles. This requires you to become a CEO, really, okay? To actually know what you're trying to do and where the vision for your company is going. So when you go in these type of negotiations or roles, or say you're hiring a freelancer, hiring a dev shop, what is your goal for them? Understanding that will go a long way in deciding how you want to draft that contract, okay? Even pursuing co-founders. Do you want them to come in as a temporary solution or a long-term partner? Know that as well. Continue that conversation. And then also bringing in any sort of contractors just to fulfill a role as well. I have been wrong. Usually when we engage anybody, like even as a client, even as a investor, even as a freelancer, we tend to quote unquote date them, put days where you do a trial period of how they work well with you. You'll find out a lot about people and how they work within 90 days if you are giving them all of the responsibilities that you would in any daily day.
I don't have anything to add to this one. That's pretty clear.
Okay. Have a clear goal. It requires you to have a clear goal.
Yeah.
Basically, what we're saying is don't be reactionary in your decisions. Be proactive. And the last one is ask people you trust. I know this is a subjective practice.
No, so this is true throughout everything. So I'll even going back to the co-founder thing, right? Yeah. When I failed with my co-founders, it's because I didn't know them, right? Like never again am I going to start a company with people I don't know and haven't tested out, like period. It was an awful experience. And it's the same thing, not just with your company, but throughout life, right? Like personal recommendations are worth more than just Googling someone and finding them. And certainly recommendations where the person recommending someone isn't, benefiting from that recommendation are worth the most, right? In fact, well, that should always be the case, but sometimes isn't, right? So if you're looking for a co-founder, ask someone, post on LinkedIn, ask someone who has a bigger network than you to post on LinkedIn for you saying, hey, my friend is looking for a co-founder. If you're looking for a CFO, ask. If you're looking for a lawyer, ask. If you're looking for CTO, go to FastCTO. You don't need to ask anyone, just go to FastCTO. But ask, but really ask. And then people tell you to go with FastCTO.
So there's also a 4-part equity test I want to share with you too, where if you are going to ask people you trust to come on as a co-founder, okay, this is very specific to bringing on people for equity, is 4 parts. The first one is time. Will that person give you a specific amount of time? Is it 20 hours a week? Is it 10 hours a week? Or what do you expect from that person? It goes back to having clear goals for that person. The second one is skill set. Do they have a specific skill set that you require? Okay, so maybe you need a technical co-founder. Maybe you need a legal person on the team. Whatever it is, do they have a specific skill set in addition to their time? The third one is, do they have the resources? So resources could be connections to a specific database, connections to a specific client base, connections to future investors, etc. And the last one is money. And the reason I put money last is it's cheap. Once it runs out, it's out. That person's value runs out. Okay, so technically you should not be bringing on anybody as an equity co-founder unless they fulfill 3 out of the 4 of those roles: time, skill set, resources, and the last is money. The last thing I'll say is, you can ask people you trust. That does not mean friends and family are people that you can trust. Okay, just because your Uncle Joe has 10 grand and he wants to give it to you, if Uncle Joe doesn't know jack about business, might not be the person for you. What you can do is take a loan from Uncle Joe for $10,000. It doesn't mean that you have to give him a piece of your company for equity. Okay? So be very, very realistic. It's because your best friends are great and they love what you're doing, but they want to sign on and be your co-founder. Take a beat. Do they know how to run a company? Will they might be able to give you time, definitely, but do they have the skill set and the resources? And have they ever run a company before? How do they handle it?
Yeah.
You know, what happens when something goes wrong, right? So these are real questions you need to ask about who you're bringing on and so forth. And again, the 90-day date test, okay? Date them and see what happens, and then consider bringing them on.
And don't assume that someone that has access to resources is willing to deploy those resources. That was the mistake that I made in actually my last startup. I won't name names, but one of the co-founders. So on paper, we had 3 co-founders. I was a technical co-founder. One was sales, and one was the Rolodex, right? Like all of our #1 clients, like potential clients, that was a connection. Turned out that the Rolodex wasn't introducing us to anyone, and that sales couldn't sell. So it does no good to have a platform that you have no one to sell to. Anyway, that's actually I would say all sorts of problems with that one. But both me and the sales co-founder, even though he wasn't doing what he was supposed to be doing, were very much misled by the Rolodex, because we both had this assumption that, like, hey, you have this book of business that you're going to connect us to. And it turned out that, like, no, just like he didn't. And we never actually figured that out until too late. So don't assume.
It's okay to ask questions, right?
Yeah.
It's thinking of contracts as living documents. Your agreements with people and your relationship with people that you engage in business with is also a living relationship, right? So you can always have an open and honest relationship and ask those questions, because this is business, right? Yeah. So to wrap this all up, this is how we talked about the certain issues. This is the future of the tech and the legal. I want to just tie it up and say, any questions going forward? I know Nicole's like, these two are yapping, but how can we wrap up any questions? And I'm going to stop my screen share here so that I can check out the questions. There's no other questions.
There's no other questions, and we found equilibrium where we have as many people online as there are left in this webinar.
Beautiful.
So I think it's time to call it quits at that point. And thank everyone for coming. I will say, Sankita, was there a URL in the beginning of where people can go to find you? If you Google,
chat as well, Biz2Co, which is bizto.co.
Hold on. Say that again. Say it again, because I'm going to put it in our thing. bizto.co. bizto.co. Boom. I'm going to put it. What? It's Biz Taco. It's a business taco. It's like taco in a suit. And then of course we've got FastCTO.com. Add banner.
I'm going to put it into the chat
Boom.
here too. CTO.com. I'm putting it into the chat in here too. And
very good.
Just put in the GF.
Yeah, I just threw in the link to sign up for the webinar tonight. So if anybody wants the link for this recording, you'll have to sign up at ga.co/webinar.
And if you found it on YouTube, you're already there.
Beautiful.
All right. Have a good night, everyone.
Thank you so much, everybody. Take care.
Bye.
Bye-bye.